All right, welcome to this week's podcast on mediation and arbitration. And I'm Dave Johnson, managing partner of Johnson Marquez Legal Group. And with me today is Heather Coleman, one of our associates.
Hey, everyone.
And we're going to be talking about mediation and arbitration. Those are two forms of alternative dispute resolution. What does that mean, alternative dispute resolution?
So alternative dispute resolution, or ADR for short, it's a process of trying to resolve your case out of court. So not having your case go in front of a judge is a goal for a lot of people, and in most domestic cases it's actually required that you engage in some form of ADR. But arbitration and mediation are two different things. They're similar. It kind of depends on what you're looking for, but they're both forms of alternative dispute resolution.
All right, well, let's define them to start with. What are the main characteristics of arbitration?
So arbitration it's somewhat like going into court in front of a judge, but you're not in court, you're in front of an arbitrator, or an arbiter. And a lot of times these people are actually former judges. They are really good at making decisions for you, but it's basically a process wherein you present your case in an arbitration setting, and then the arbiter has authority to make a binding decision. So whatever that person orders is what is going to be ordered. Even if it's not in front of an actual judge in a courtroom, it's the same type of setting.
Okay, so it's almost like setting up your own private little court, right?
Yeah.
And how is that different from mediation? What's mediation, and how does it differ from arbitration?
So mediation is a process where you're meeting with a mediator. They're a neutral third party. They don't have any authority to make binding decisions or orders. They're there to help you resolve your case. And if they do help you resolve your case, great. You guys will sign an agreement, walk out with a signed agreement. But if not, you haven't resolved your case. There's not going to be any sort of orders coming from it.
Okay, so let's talk a little bit about arbitration and why somebody might decide to use arbitration as an alternative to going to court in front of a judge.
Right. I think there's a few times when you might want to pick arbitration over going to court. I mean, it's number one, it's going to be less expensive. It's not as thorough of a process preparing for arbitration as it would be for a contested court hearing in front of a judge. So number one, I think, is the costs. Number two, maybe it's just an issue that really doesn't require a full-blown hearing. Maybe there's one contested issue left for your case, and you guys have been trying to figure it out for a while, and so you kind of just come to the agreement, well, maybe arbitration will be best for this one issue. And of course there's a lot of situations where going to courts is the best option, but I think arbitration oftentimes is a much better alternative.
Okay, so in arbitration, basically how it would come to be is that you've already filed for divorce, and the parties agree to take the case to arbitration, right? Because you can't be ordered into arbitration.
Right. There has to be an agreement to use arbitration. It's not something the judge is going to order. The judge can certainly order that you attend mediation, but not arbitration.
And that's because in mediation there's no forced outcome. If the judge were to order somebody into arbitration, that would basically be ordering them out of the courtroom and telling them that they can't come to court to get a decision, right?
Right. It's kind of like in a previous podcast we discussed different custody experts, and one of those is a decision maker. That's someone that you have to agree to use because they have binding authority to make decisions for you. So just like a decision maker, arbitration, if you take your case to arbitration, they're going to issue a binding decision. That's something you have to agree to beforehand.
Okay, and so, but once you've agreed to go to arbitration, and you're in the arbitration, you get an award, you can't just go, well, you know what, I don't like this, it's time to go back to court.
Yeah, I mean, the reason you chose arbitration is because you wanted a binding decision out of the courtroom, and that's what you're going to get out of arbitration.
Okay, let's talk about the arbiter, the person who is the decision maker. You don't have to have just one. You can have, the most common number of arbiters in an arbitration are 1 and 3, because in 3 you've got a tiebreaker. But you get to pick this person or these people, right?
Yeah, the decision is completely up to you. I mean, preferably you come to an agreement on who you want to choose to conduct the arbitration. But a lot of times, like I said, arbiters they're former judges. There are groups. One that comes to mind is called JAM. It's a group of former judges that now conducts arbitration sessions.
Right. And the thing about picking an arbiter instead of just going to, I mean, if you just file a district court case and you're going to go into your divorce that way and go into a hearing in front of this judge, that judge may have been a corporate lawyer in their previous life, or may have been a criminal defense lawyer, a prosecutor, or a public defender. Those are common, sources for judges. They may not have a whole lot of experience with family law, right?
Yeah, that's a good point. With arbitration, you can pick who's going to be the quote-unquote judge in your case. Whereas, if you're going to take your case to court, I mean, you really can't. A lot of times judges that have been placed in the domestic courtroom have zero experience in domestic law.
Right. And with arbitration, you actually get to pick somebody who has experience. You may even want to pick somebody, you don't have to pick a former judge. You may want to pick somebody who's been a psychologist or a therapist or somebody else who's been involved in these sorts of cases before, right?
Right. And just as an example, say, your issue really boils down to a real estate issue. It's related to your divorce, but it's more related to real estate. Then you have the choice to pick an arbiter who has 100% background in real estate law.
Right. So let's talk about the actual process of arbitration. It's not just basically you sit around, tell your side of the story, and then the arbiter decides, right? I mean, this is actually like a courtroom with evidence and witnesses and experts and documents and things like that, right?
Right. You're going to prepare the same way. It's just you're not inside an actual courtroom.
Right.
Yeah.
I mean, you don't have a whole lot of kind of the public pressure that comes with going through the metal detectors and sitting out in the hallway and wondering who that person is sitting in the gallery behind you. So it is a much more private setting. I don't want to call it informal because it's really not. I mean, it's a serious matter. This will be decided, and there is going to be an enforceable order. So it is serious. But it is a lot of people say that it's a more comfortable environment than going to a courtroom, right?
Yeah, like you said, it's kind of like your own private courtroom. You don't have the pressure of going into a big scary courthouse. It's going to be at somebody's office. It's still going to be a somewhat formal proceeding, but it's not going to be in an actual courtroom.
Right. And we talk about cost difference of going to court versus going to arbitration. As a lawyer, you still have to prepare for arbitration, even though maybe the rules aren't the same, that you're not going to have quite the same sort of hoops to jump through. But you also have to pay for the arbiter, right?
Yeah, you do have to pay for the arbiter. So there is that additional cost to consider. But I mean, overall, I still think, for a lot of people, choosing arbitration is the more cost-effective way to proceed. There's also a lot of hoops the court makes you jump through as well before you can actually get to a judge and decide your case. But if you make the choice instead to go to arbitration, there's less hoops to jump through.
Right. I mean, even time-wise, just simply shortening the case can save clients a lot of money because you don't have to go through the typical deadlines that you would have to go through in if you went through district court. You still have the jurisdictional limit of having to wait 90 days because that's just simply the law. But you also you could set your arbitration on the 91st day and pay the arbiter to be there on that 91st day, right? Right.
And, going through, the actual courts for a contested hearing, I mean, you may be looking at a really long wait on the court's docket. Some counties are scheduling out 6, 7, 8 months, whereas you're not going to have to wait that long if you go with arbitration.
Right. Let's talk about the privacy element. A lot of people don't want other people knowing their business for one reason or another. Maybe they've got a lot of wealth that they don't want exposed to the public. They don't want sworn financial statements stuck in some clerk's box. They would rather keep everything private and out of the public eye. Arbitration is a good way to do that, right?
Yeah, I mean, you're working with a private individual, a private arbitration firm, whereas with courts, I mean, your court case, the vast majority of it is public record, and somebody could look it up if they wanted to, including, documents that were filed in preparation for hearing, any orders that were issued from the hearing. Those are generally all public. Right.
And again, at the end of an arbitration, you get a final and enforceable order, right?
Right.
Right. So in mediation, you don't get a whole lot of that. I mean, again, you go and you try and you resolve it. Mediations tend to be most of the time successful, right?
Yeah, I mean, I would say the majority, more than 50% of mediations do result in a successful outcome and a signed agreement. So, I mean, definitely don't think negative about mediation because it's often, the best way to settle your case.
And it can also be quick and less expensive. It certainly is a less expensive way of resolving the case, but it can be quicker than waiting for the hearing.
Oh yeah, I agree.
So, but and the court can order you into mediation because it may not be successful, and you still have your court date. You can go and resolve it in front of a judge, but you don't have that certainty that if I go to this mediation on this day, this case is going to be over. Because you have that certainty in an arbitration, right?
You're right, right.
So Colorado now allows you to mix both of those together in a med-arb setting, right?
Right.
And what would be the advantages of setting your case for, well, first of all, how does that work? What is med-arb?
Mediation, arbitration, a combination of the both of them. So basically, you first try to resolve your case in a mediation setting. If it's clear that you're not going to come to an agreement or there's a stalemate, then whoever is acting as the mediator arbitrator is just going to make a decision for you guys.
Right, and so it can be, again, because the arbitration side of the med-arb formula is private. It's contractual. You're going to sign an agreement that says this is what you're going to do. You have a lot of flexibility in what happens with the arbitration side of that formula, right?
Right.
I mean, you could say immediately following mediation, the arbiter is going to hear arguments and then issue an order. Could be done the same day, right? Or it could be that we're going to do mediation, and if that's unsuccessful, then we will set it for arbitration in a month or something like that.
Right, or something like if you guys go to mediation or unable to come to an agreement, then the mediator arbitrator will request that you guys present an argument to him, and then a couple days later he will issue an order.
Right. So I mean, you have a lot of flexibility in that med-arb setting. Have you ever been involved in any of those?
I have been involved in one, and like I just said, what happened with us is, we went to mediation, we settled some issues, there was one remaining issue, and the mediator arbitrator said, okay, you know what, you guys, I've heard both sides of the story, I'd like you guys to present me with a final argument, I'm going to make a decision, I will send it to you guys in a couple days. Okay.
But I mean, you've only seen one of those. I think maybe I've seen two of them, maybe three of them, a med-arb. Why do you suppose they're so rare?
I don't think it's something that really comes up that often. I think a lot of people are kind of afraid for their mediation to turn into an arbitration. They don't want it to go that route to start with, so it's not something they want to pursue. I just don't think it's that common. I don't think it's something people think about or even talk about very often.
Yeah, I don't think that it's offered up as an option a lot of times. Honestly, I don't think that a whole lot of mediators want to get into the position of arbitrating either.
Right.
Because it's like everybody knows that that's coming, and so if they don't settle, so why stick your neck out? Why put in the hard work? Why put in that extra effort? Sometimes there's drama. I'm storming out of here, because you can't really storm out of there in an arbitration, right?
Right.
In a med-arb, because you got to sit there because the arbitration part is coming. So it's in my experience, not a whole lot of mediators are eager to do a med-arb arrangement either.
Right, unless they have unless they are an arbitrator and they provide mediation and arbitration services, then it's something they might offer. But yeah, I'd say it's pretty rare.
Yeah. All right. What is your favorite ODR route ADR route to go?
Definitely mediation. Mediation is something that you're generally going to have to do in every case, and I honestly think that mediation is just the best way to try to resolve your case. I do think arbitration is appropriate in some circumstances, but you have a really good chance of settling your case at mediation. It may be a long process, an all-day process, but if you walk away with the signed agreements and you're happy with it, I think mediation is the way to go.
Yeah, I think mediation is the most cost-effective way of resolving these cases, and mediation teaches you how to resolve your own conflict. So if you are successful in mediation, sitting there working together trying to figure this out, sometimes it can get nasty, but nonetheless you figured it out without having to go sit in front of somebody else and ask for a resolution.
Right.
And that problem solving technique, if this case has any chance of coming back, for example, modifying child support or modifying maintenance or modifying parenting time, this case is probably coming back to court. If you've done mediation successfully before, you're likely to go back to mediation successfully again.
Yeah, I think that's true. I think, if you are able to settle your case initially and then something does come up, you're more likely to be able to settle it in the future too.
Yeah, but arbitration, the downside of that is, even though this may be private, and you may get a really experienced judge, and it may be quicker, and maybe a little bit cheaper, you haven't learned to dodge the decision maker and the process, right?
That's true.
You haven't learned to solve the problem on your own. You've still kicked it to somebody else, even though it's more private and maybe more experienced.
Right.
But sometimes that's the best way to do it. And oftentimes when there's a significant marital estate, and there are issues there that everyone wants to keep private, arbitration seems to me to be a really good tool, and that's the few times that I've used it is that there were reasons to keep this case private, and it was a significant estate, so it was worth the time and energy of finding a really good arbitrator and kind of avoiding the public spectacle and having other people have access to the records.
Right.
But I did like the Med-Arb formula when I did it, because it was like, you knew that you were in one case that I'm thinking of, the other side was unreasonable. It was clearly unreasonable with what they wanted, and we tried as hard as we could to get them to see it logically. The mediator was trying as hard as she could to get the other side to basically see the light, but they were just not going to get there. And then the mediator switched hats, became the arbitrator, and we got there.
Yeah.
So it was a good tool to handle one of those intractable positions that a mediator sometimes comes up against.
Yeah, that's a perfect example of when mediation arbitration would be really beneficial. If somebody's being super unreasonable in mediation, the mediator was there to witness that. They put on their arbiter hat.
Yeah.
And they make the other party realize, what's going on.
Yeah, I think it makes you behave a little more during the mediation too.
Yeah.
So if arbitration's coming. All right, any other thoughts on mediation, arbitration, and Med-Arb?
Yeah, I mean, you are going to have to go through some form of ADR in your divorce or custody proceeding. It's a good idea to start thinking about what might be best for your case and kind of weighing the costs and benefits that we discussed today.
Yeah, I think evaluating your options when it comes to ADR is important, because you're going to have to do it. Mediation is the default. Med-Arb is a useful tool. Arbitration has its place, and having that discussion with your lawyer, which of these tools is best for you, is a good one.
Mm-hmm.
All right, thank you very much. We'll see you back next week.
Bye, everyone.